Great. So let's start this presentation. What is pre-21st century legal ethics? So what is the current status? So I'm going to go through the presentation. I kept the slides that I had in terms of like, where are we coming from? Law is really a technology enabling human collaboration. This is what Ixian philosophy is. The beginnings of law, like the law is an emergent phenomenon. I'm not sure how this has been already discussed. It's very context rich. The start of legal innovations really was about consolidating power and facilitating trade. With the Akkadian Empire, we saw the beginnings of standardization. We saw administrative systems and accounting that facilitated trade and growth. And then with the Napoleonic codes, we saw the dismantling of local parliamentary rules and imposing codification of the legal system to match the new political reality. And then, as we know, Napoleonic codes are at the heart of all civil law systems today, not common law. And then in comparison with Roman law, that had that philosophy that like we never deleted anything because we thought that law was sort of like brought down, like sort of transcendent from the gods. And then like we never deleted, we never gardened, we never pruned anything in there. And then it became something completely immanageable, like impractical. And then today we are at that point, right? Unevenly distributed. Some countries have very good law or very complex law or very sophisticated law. Other countries have very weak legal systems, very poorly drafted, copy-paste from various other places. Law is excessively complex in certain areas. And then like as we are going towards more and more complexification of like all the noosphere, all the human society things, like law by definition is part of that. So it's becoming very, very complex, but at the same time, we haven't pruned our garden, right? We haven't actually went in there to decide what's still useful, what should be made consistent, etc. And then again, it's internally inconsistent because it has evolved over time. We kept piling things up and nobody was actually doing this very needed work of pruning what's no longer relevant and needed. And what does legal engineering mean? Is about better designing and implementing legal frameworks and operating systems. We do want to preserve the principles of rule of reason, equity, freedoms, human rights, and we want to do what works, use the technology and automate as much as we can, make it easier for people to be people, and then to be held and supported by these legal frameworks and operating systems. Okay, but legal ethics is also an emergent phenomenon. So the origin of ethics is in the Greek philosophy, justice, good outcomes, Plato and Aristotle, and then Thomas Aquinas and the nature of humans, and then Kant's sense of duty. In the United States, I want to specifically mention Lincoln's lecture on the practice of law in the 19th century, because he had a very pragmatic approach. I like pragmatic. He wanted to, he advised young lawyers to discourage litigation and seek compromise between the parties, that no exorbitant fees should be practiced. To preserve commonality of interest with the client, for example, he said, if you get all your fees paid up front, you must be a saint to really make your best efforts for your client afterwards, right? So it's like try to align your interests with those of your client to make it easy. And then again, allowing people to be people. And then the diligence when preparing client work. And before the 20th century, actually, the practice of law was fairly unregulated in the United States. And I'm going to talk about rules of other countries, mostly in the European Union, because this was short notice. I didn't have a lot of time to do lots of research, but I do have enough so that you have a very clear picture of how fragmented we currently are and how diverse, which is a very good point to see that a lot of these legal practice rules, legal ethics rules are really cultural trappings and are not of the essence of the legal work. Okay. So the practice of law rules in the United States, it started with the American Bar Association being set up at the beginning of the 20th century, which promoted lawyers becoming a profession. And that this was meant to ensure better standards, better quality, but especially meant to protect the profession of the lawyers to have them accede to a higher status and a higher income. So they published the Canons of Professional Ethics in the early 20th century, which turned to a model code for professional responsibility, and then the ABA model rules of professional conduct, which are still applicable today. What is important to notice here is that the rules essentially reflect the status of the profession as it evolved over time. It was a fairly homogeneous group. The practice of law was predominantly local or regional, mostly generalists, heavy focus on litigation, individual clients, and then solo, very small private practices and fairly unsophisticated client base. So we see that we're very, very far away in the current context where we are working with emerging technologies, very modern rules, worldwide, cross-border. We're very, very far from that. So the rules of the practice of law in the United States are fairly inadequate by today's standards. And especially something to note, and I'm giving just an example because I'm not sure how much time we have, and then I don't want to go very deep in the weeds on this, but I want to give you the example of the unauthorized practice of law, because this typically comes up a lot when we're talking technology and technology providers, and then generally how things are done. In the United States, a lawyer may practice law only in a jurisdiction in which the lawyer is authorized to practice. And while you may be thinking of the United States as one block, it's not, right? It's right, like state by state by state, there are different jurisdictions. Therefore, a lawyer cannot actually help his client. The same client, corporates are not prohibited from doing, business in other places. So essentially, a lawyer cannot actually help his client if he does business in, like, if I'm qualified in New York, and I actually am, and I cannot actually help someone who is doing business in California unless I'm in a very specific restrictive mode, get assisted from someone over there, very, very, very specific restrictions. So this blocks commerce. This is a barrier to commerce, because commerce nowadays, we way past the time where businesses were just local or regional, right? If this was just related to litigation, it would be understandable, but it actually applies to all legal advice. What actually happens in practice is that we have a proliferation of lawyers. We have a lot of lawyers per capita, actually. I think the latest statistics I saw in the United States, we had a little bit like a lawyer for 300 people or something like that. That's a lot of lawyers if you really think about it. Like, how about the European Union? So, like, European Union is mostly countries in continental Europe. They're based on, they evolved over the civil law systems, as we saw the Napoleonic codes, but we still have a tremendous diversity of legal practitioners. We have over 40 professions. They have different training requirements. There are different professions within the same country. Some countries require a degree, some others don't. The qualifications take 3 to 6 years, depending on the country, and professional experience is like training on the job is often a requirement. We also have notary public monopolies with the numerous clauses. So essentially means a fixed number of people who can do this profession. So for you to take over, you need to take, like, to go into this profession, you need to take over from someone else, which again, it creates barriers to entry. It creates a sort of entrenchment positions in these professions. The United Kingdom, for example, and like it's not the EU anymore, but it's still in there because it's close enough. Solicitors and barristers. In Spain, we have special lawyers who do pleadings in court, the procuradores, and then we have special lawyers dealing with labor issues. In the Netherlands, we have special lawyers dealing with tax advice. They're actually special professions, right? In the same way as in the US, we may have the patents lawyers that are very, very different from the others. In France, Luxembourg, and Germany, for example, lawyers have actually a monopoly on giving legal advice, but not in other countries in Europe. And then, we have a lot of incompatible activities, which are different country by country. Mostly, so I used to be in France. I also I'm qualified in the UK, so I looked at all these things. I looked at Switzerland as well. So Switzerland is a little bit more flexible. But general in France, for example, I couldn't do anything except teaching or working as volunteering as part of an association. All commercial activities were prohibited. In Belgium, it's even worse because the practice of legal profession is deemed incompatible with remunerated employment. So that makes it very, very dispatched, very fragmented. And then we do have a harmonization attempt right now in terms of the Council of Bars and Law Societies of Europe published a charter, core principles. They did this. And we have this very important concept in Europe, in all continental Europe, that a lawyer is an auxiliary of justice. A lawyer must serve the interests of justice first and then his client. And then it requires certain personal qualities, and then it requires protecting the client's confidentiality second. There is a lot of restrictions because of this auxiliary of justice mindset and ethics, which we don't find in a lot of other places, right? And it requires a lot of impositions and restrictions in how we do publicity, how we handle conflict of interest, how we set our fees. For example, in Europe, success-based fees, like sharing a percentage of the outcome of a litigation, it's prohibited. We cannot do that. And also we cannot share fees with non-lawyers. So obviously navigating all these rules is very complicated, very complex, very country by country. So the profession is still very fragmented. And some of these rules have been eroded by new obligations imposed on lawyers in terms of compliance and anti-money laundering. And those are eroding even the concept of protecting client confidentiality and privilege. So the current landscape, and this is sort of my slide for discussion purposes, and really I'm hoping to have some discussion about this. Highly fragmented, big law can draw upon expertise from several jurisdictions and additional resources, but otherwise lawyers are really in a bad place. They do not have requirements for computer technical literacy. We have mandatory continuing legal education, but it's mostly on substantive issues, ethics and diversity, not technology or business acumen, which actually it's a barrier to innovation as well. And in the name of protecting the public, lawyers are confined in what they can do and have many professional obligations. For example, we need to keep client funds separate. We need to have certain obligations and filings with respect to providing escrow. We need to, manage conflict of interest in a certain way. There are a lot of rules that actually occupy a lot of the lawyer's time and do not leave a lot of room for much innovation. It seems like the system evolved from one perspective where we took a few anecdotal evidence cases that this client abused, this lawyer abused the client, or this lawyer took advantage of another, or and there are highly unethical behaviors that still happen. But because of those highly unethical behaviors, which are, let's say, carried out by lawyers who are in there for the money or because they have a certain personality and psychology, because of that, we kind of limited the entirety of the profession to a great extent, and it's blocking innovation now. Okay, so this was my slides, and I would like to open it up for a conversation if we can.
Great. Well, I guess, do you mind stop sharing your slides and then we can?
Yes. Perfect.
Great. Yeah. So yeah, do people have any particular questions about what was just presented? I can guide the conversation if something doesn't. Yeah.
Maybe this is coming in the next parts, but it seems like we got a good problem statement of the reputation, understanding why. And I'm curious how legal engineering or how you're trying to solve that, if it's even possible.
Yeah, Ramona, why is it that we Ixion we feel that Ixion is a place that we don't have risk that we would otherwise if we practiced legal engineering, say, in USA.
Well, that is specifically something that I think Christian will talk about later in terms of like the jurisdiction of Prospera, the special economic zone of Prospera where we are set up. We do have some of the restrictions, right? Like personally as individuals, when we show up and we provide services, we do need to be mindful of those rules of the countries that are impacted, right? But like Ixion as a company being set up in Prospera, which is a special economic zone, which allows for a lot of more flexibility to innovate, we do have fewer restrictions because of that, in terms of what the company can do, right? So we can distinguish between us doing innovation and then doing work to really build like legal products, for example, versus the work that we do as individual lawyers as for a specific client. And then also Prospera is it has adopted this polycentric law approach that Christian will explain more in depth, where they are accepting, like if I'm a lawyer qualified in New York and or the UK or elsewhere, I can actually advise my clients in Prospera on those areas because I'm deemed to be qualified, right? And it's my problem if I'm not doing it properly and I get sued. That's a different story. But it's like there's no separate mechanism that Prospera is going to implement, and I don't think they will ever will, because it will become unmanageable really quickly, and their purpose is to streamline, to regulate how people are actually offering their services. So there is a presumption of competence that is backed up by this threat of like liability, professional liability, or arbitration. In the sense that, like, there are some rules that are very good, like rules evolved for a reason, right? So if we go back to how most of these rules evolved, they evolved around specific cases where you had a conflict of interest, which was tough, or there was a lawyer that took advantage of a client, like that was in a weakened state, right? So those examples reached such proportions, were such egregious behavior that actually went to court, right? So they had the litigation happen, and then the entire profession is like, wait a minute, we can't have this. This is not good for our reputation. It's not good for our profession. But I would like to think that, or maybe I'm wrong, but I would like to think that we've evolved since then. So even in the sense that, first of all, law has complexified to such an extent that having the presumption that a lawyer can do everything that's law, it's ridiculous. It's just absolutely ridiculous. So whenever I had someone is like, oh, you're a lawyer, you should know, the law is immense, right? It's really immense. This is why we currently advise, and it's good ethical practice to have specialization and to just advise only in the fields you're actually competent in to advise. And then it evolves into a profession where lawyers need lawyers to advise them, to keep them up to date. We have evolved inside of the law firms. And I've been working in big law firm and as well as small law firm models. And we have evolved the model where we need knowledge management internally. We need to keep ourselves. So there are legal, like continuing legal education. We need to stay on top of what happens. And this is why we go to conferences, we go to events. This is why we keep researching. However, this requirement and this legal ethics requirement is at odds with the business models of most law firms and how they currently evolve in terms of putting a lot of pressure on lawyers. There was a very good example that was given recently by someone I admire. Is like, okay, so you're hiring your new starting lawyers at a certain price, right? You compete on price, so you want to attract good lawyers, so you pay them a lot. But because of this, it creates a pressure on them to invoice 3 times their salary, to be sort of adequate and not a burden on the firm. Which means that, first of all, you're billing the client for a lot of time spent for the young lawyers to learn on the job, which is unethical. And second, you are actually not allowing these young lawyers the time to actually learn. because all their time is supposed to be spent in billing matters, because otherwise they won't meet their requirements. And billable matters, billable hours, they're not dictated by their interest or consistent or going in a certain specialism, or like, and you end up with this sort of very artisanal models where if they are working in a big law firm, they actually get some training and they get some support, but otherwise they're learning on the job, client by client, starting from scratch every time. And then but they're billed top hour. Or in some of the law firms I've seen, essentially you leave the young lawyers without secretarial support and staff support. You force them essentially to do a lot of admin legwork, paperwork, which should not be billed to the same model, right, to the same price. But because so you force them in an unethical position to either write off their own time to remain ethical, or to bill that time to the client because they want to have a life and meet their objectives. It's like you create this conflict of interest due to dysfunctions in the systems and in the business models.
Yeah, that's really interesting.
And we've sort of diverged from the initial questions, but essentially like Prospera allows for this flexibility, which is why we can innovate. And at the same time, it's sort of like, this is why the dysfunctions happen, right? They're not planned. Like, not everybody's an evil lawyer out to get you, but essentially, like, you have competing forces and conflict of interest in the very business model of the law firm.
Yeah, and as problematic as rent-seeking software as a service is, it at least does it does encourage automation, where billable hours discourages automation. It's manual. One thing you said earlier that I would just like to note is patent agents are not all lawyers. Some of the patent agents can't be lawyers because they need to be specialized in that area of engineering, and usually they work alongside a patent agent who is a lawyer. But that's an example of an area where someone is highly specialized in legal practice. All patent agents are, but the one who's actually writing the patent might actually not have a law degree, even though they've got a co-pilot who has that law degree, just because of the necessity. And then one thing Tony Lai and I were chatting about at that Stanford Codex event I was mentioning earlier in April, is the idea that lawyers, especially legal engineers, and in this environment where so many people, Solidity developers, are experts in that particular field of law, and they're the creators, that it's much more like a musician and a producer. So the lawyer is the producer, the musician is supposed to be the expert in their genre, all that, but the lawyer is there, as a producer, to make sure that it gets on the radio and it's professional quality, all that. So it's more of a facilitator role, and that's an interesting thing to explore. So Ramona, I'm going to show my screen real quick, and then I'm going to ask you if you think this is a problem in traditional legal ethics, or if it's fine. So right here, so this is the Hatch tree. We spoke about this earlier, and we'll be speaking about it throughout the week. And this is the legal engineering curator. So something I've done on purpose is, because I'd like to have this legal question answered, is right here, that we're increasing HAT adoption by deploying HATs as a law firm for clients. So in this, we're in some sense, we're making a product, but that product is tailor fit to a particular client. So no one else is going to want to use that product. And then the client then uses it, the HAT, in their day-to-day operations. But as far as I understand, in traditional law, the lawyers are not supposed to do their clients, run their client's business for them. And this is arguably crossing that line. So I'm wondering what your thoughts are, if you have any other flags, that if this were in a jurisdiction that isn't sandboxing and safe harbor for innovating on legal ethics, where this could potentially be problematic, offering this kind of service, which for HATs, it's an adoption problem. Org charts are complex, and so this might be a way that HATs can have more adoption, as if law firms do this tailor fitting. But yeah, what are your thoughts here, Ramona, if you have any?
Generally, you're absolutely right in terms of lawyers being prohibited. It's like this is one of the restrictions that derives from both the conflict of interest and the rules of professional liability. So the lawyer is not supposed to get mixed in his client's business, right? It's supposed to, because of this sort of philosophy that lawyers are supposed to be independent and maintain their independence and also be sort of an auxiliary of justice. We cannot do the same type of implementation work that would really support the client compared to what traditional business advisors can do. Like traditional business advisors, project management advisors, they can do that for their clients, right? Even if they're consultants and not really working for the client exclusively, they're allowed to do that. Lawyers, because of this philosophy of being an auxiliary of justice and requiring to maintain independence and so on, they're kind of restricted from doing a lot of this implementation work, which has the very dysfunctional effect of leaving the client in a bad place where they end up, they pay a lot of money to the lawyer. They come away with a sort of a pack of like memorandum or instructions or contracts or a policy or something, and then they are left on their own. And then 3 years later is like that package was put on the shelf or was implemented internally, but like imperfectly, right? Because of course you cannot have different people, especially if they are not lawyers. So the companies who can afford hiring their own GCs, they're in a better position in terms of having the general counsel who is able to take over that and then make sure that it gets done. But the small clients cannot.
Sorry, Ramona, I just wanted to make sure everyone knows what general counsel is, that it's a lawyer that's an employee of a company. So they are not doing billable hours, and more GCs as well, fractional GCs. That's the solution, because just billable is, unless your enterprise is untenable, and if your enterprise, it's a worthwhile moat, oversimplifying. Sorry, Ramona, please keep.
No. So because of this, most law firms shy away, and then like professional liability rules are actually important because the bigger the law firm, the more complicated it gets, the more expensive the policy, and the more they need to create these committees and make sure that they are doing things in a certain way. So this is very clear for us from the beginning in terms of when you get trained as a lawyer to work in a law firm, you cannot do certain things for your client. You're not supposed to get involved in their business. You're not supposed to take over or do things for them. If you do that, there is a sort of a problem being created at the level of the liability. But like also more importantly, when working with technology, the problem is that you have two separate groups of people working together that don't speak the same language. So you have the lawyers on one hand that speak legalese, right? And you have the technology people or business people who speak their own language. And there hasn't been an effort other than like lawyers who are actually going in-house for a big enough company. There's not enough effort from a law firm perspective to actually adapt to innovations explored in other fields, in other industries, to speak a common language, to work together, mostly because, again, it's a business model issue. If nobody pays you to do that, it is very hard for a lawyer in a law firm to actually go out and build. Like, think about how industry generally works or technology. You first go out and you build your product. You make sure there is like product like market fit. It works as intended, and you test it, and then you iterate on it, and then you sell it. A lawyer is very artisanal. Like a lawyer is like hired services, and therefore is like it cannot like innovate and build this product and invest its own time to make a product. Also because the rules about personal publicity actually prevent you from going out and like advertising properly. Lawyers have a lot of restrictions in terms of what is the advertisement that they cannot guarantee results. Like, first of all, they cannot promise results, They need to be very careful in terms of what they're saying, how they're saying it. They're not supposed to do marketing properly, right? So this prevents them from actually, even if they had the time to invest in building a proper product or proper expertise in a certain area, it would be very hard, either by publishing articles or going speaking at conferences. It's very, very difficult for them to actually market it. It's like to reach their audience. So especially it's just them, right? They're like talking to a conference, going to meet people, and then seeing what you can do for them. It's very artisanal, very manual process. So the entire profession, like the legal ethics, the practice of law, has evolved in this very artisanal, very 19th century, sort of early 20th century way. But then now we no longer do business in the same way. Right. So lawyers are very hard to adapt.
Yeah. When you say lawyers are restricted, who's restricting lawyers?
So the professional associations and the bar associations and like business rules in terms of the conduct, right? So lawyers have this obligation to register to a national bar and comply with certain rules in terms of, and law firms as well, right?
Just real quick, just because we've got 6 minutes.
So the self-regulation of the profession that we started with, and you mentioned at the beginning, but like these bar associations and professions are restricting them, and also the courts will enforce that. Right. So the courts will enforce that if a law firm goes and does all these things, they will be penalized in terms of administrative penalties by their bar registration association and so forth, and then potentially other things.
So you would say that perhaps the jurisprudence community is a barber who shaves himself in that Russell Brand.
Well, we have self-regulatory authorities, but it's like they're still authorities, right? It's like they're to be taken seriously. They're not, just loose, soft.
Well, that's, so what I'm getting at
here. It's not a soft law approach. It's not a soft law approach.
Definitely not.
It's a professional guild approach. Yeah.
It is. Yeah. So, but it is one of those complexities from a computer science perspective, the Turing halting problem. That's what I'm getting at here. So, I don't see a way around it. Though we will discuss later on, perhaps we have non-lawyers who are also part of the regulatory body. That's something we could consider, but maybe that is a horrible idea. But when we later on, I think we'll get into that because this is just the state of art. But it is something to flag from a computer science perspective whenever there's a self-referencing function, because that's turtles all the way down.
I've seen a lot of initiatives recently in this. There seemed to be this momentum emerging. I've seen a lot of lawyers becoming very outspoken about how legal education is outdated, like legal training models, the barriers to entry in terms of the legal profession are outdated, because they argue it's like, okay, but forcing me to spend like 3 years in a general legal education is good, but then I don't see how this actually helps me deliver the proper service to my client. So in terms of, they argue that it's practically removing the attention and removing the resources towards a moat that's been created around lawyers as a profession. And it's essentially like they created such a moat around themselves that now they can't actually bridge towards the other industries and the innovations happening in technology and so on and so forth, because it's actually blocking them from doing things. So instead of protecting their own interests, this moat has now turned against them and is sort of isolating them and making them into an island.
Yeah, and one thing I'm a narrative I'm saying, and this could be a narrative you disagree with, so I'm not speaking for you, but that lawyers right now are coachmen or coach people, whatever, but that they're horse and buggy, and that's been around a very long time. That's the legalese, right? And now lawyers are being chauffeurs. So that's as well as legalese. It's JavaScript. It's the evolution of language, just like it's the evolution of transport. And so you have to care about shoveling the horse's output, and then the other one you have to worry about making sure the oil doesn't go away and your engine seizes. So they're very different kinds of concerns, but there's also a big overlap. And that's one thing I'm saying legal engineer is in some way is that switch from horse and buggy to coach person, and then to chauffeur, coach to chauffeur, and a self-regulatory body, horse and buggy, coach, self-regulatory self-regulation looking at chauffeurs is going to it's going to be problematic because the self-regulation is what, right? So that's kind of what I'm evidencing.
I'm like, that comparison is hilarious to me because I've always referred to lawyers as sort of high priests in terms of like the keys to the kingdom, and sort of like they know how to get to people. Like for me, for example, like I went to law school initially in Romania right after communism, and then it was like half of the law school wanted to go into politics and actually did go into politics. So law school was an on-ramp for getting into politics. So it's more a power thing now versus is like, okay, you know how the system works, you can make it work in your favor, versus no, we're actually problem solvers. We want the system to run better, more efficiently for everyone, right? So it's sort of, again, it's like the intention to begin with was good in terms of correcting those dysfunctions, but because the system added more and more rules and complexified, and like, again, it's sort of created a lot of more things. Now it's no longer working as intended, and it created other dysfunctions that are not being seen because nobody's looking at this. Well, there are a few people looking at this from a systems thinking global perspective. It's like, okay, how well does it work? But it's very hard to intervene. And speaking about unification and harmonization, one of the things that
but we do have a hard stop.
Okay.
So yeah,
I could chat all the time about this. So I was like, hey, yeah.
Yes. Well, we'll have 2 more sessions. This is just part 1, and hopefully we'll have availability to join those other ones as well. But otherwise, I've personally been elucidated quite a bit. It's always an honor to have learned from you, and hope everyone else enjoyed it. Sorry we didn't get to other questions, but one audience question. But with that, we'll move it over to Artem and decentralized governance. Thank you, Ramona.
Thank you, guys. Have fun.